Hello everyone, my name is Anushka Kalpee and welcome to Intellectual Property 101. I'm going to be doing an introduction to intellectual property with you today. So thank you for tuning in, and also thank you to MusicTT for allowing me the opportunity to host this webinar. I am actually a practicing attorney in San Fernando, and one of my favorite areas of law is actually intellectual property. It's pretty amazing, the human mind, the human imagination, how we express our thoughts through creation and innovation. And we have that opportunity to protect it. So let's just jump right in. So the first question you'd want to know is, what exactly is intellectual property? It's the creation of the mind. More specifically, it's the creation of the express creation of the human mind. And I've listed some examples here for you to see what could be protected. An invention that would actually attract a patent protection, a novel, paintings, musical compositions, that could actually attract copyright, especially a computer code as well, even architecture. And a symbol would relate to a trademark. Now, the next question would be, why is it important? Intellectual property rights are basically a number of legal rights, and they're important because not only do you get to protect what you create, but you could also actually exploit it commercially. And when you have that incentive, that encouragement, of course, creativity and innovation you would actually be doing more, putting out more work. And so that could actually bring progress and development and can very well boost the economy, boost your business, etc. Right, so intellectual property, there's actually two types, two branches actually. On one hand, we have copyright and related rights. And on the other, we have industrial property. Industrial property would relate to trademarks, patents, new plant varieties, GIs or geographical indications, industrial design. These are just a few, by the way. But I'm going to be touching on copyright, trademarks, and patents. Just an introduction. So what exactly is copyright? Copyright provides protection to authors on their creations. Now, you can't protect an idea. You can't just have an idea sitting in your mind. You actually need to express it, make it tangible for it to attract copyright protection. You have to actually express it. So it exists in original literary and artistic works. And I mean by original, you actually have to create it yourselves. Copyright protects against unauthorized copying. So please, keep it original. And this includes, as I've said before, musical compositions, art, photographs, sculptures, programs, even maps as well, dictionaries, and as I've said before, architecture as well. It's important because when you protect your creative output, it gives authors, copyright holders, creatives that incentive and that economic incentive to increase production. You will put out more content, etc., of your work. Now, as for formality, copyright protection is automatic. Once you create something, the copyright, it comes into existence and you're protected. What you can do is that you can assert your copyright by using the copyright ledger and that's C if you want. And you can have it, you could display it on your works, any work that you create. So moving on, copyright divides into two further rights. We have moral rights, and as you can see, we have economic rights. Moral rights relate to the right for the author to have his or her authorship recognized. That means you have the right to display your name on your work prominently. And you can also object to how the work is being used, if in a way that it could harm your reputation as an author. So that's moral rights. Economic rights relate to the financial reward that you get from the use of your works. So you can actually authorize, prohibit, certain things like distribution, adaptation, for example, like a novel into a play, translation into other languages, broadcasting, public performance, and reproduction in various forms. Now you've heard of moral rights and economic rights. So can you as a copyright holder transfer your copyright? You actually can do that, and you can do that in two ways. You can do that via a license or an assignment. A license is basically permission. You give permission to someone. You authorize a third party to use your works for a specific period of time and for a specific purpose, but you keep the ownership. Assignments, however, you transfer the ownership completely. Bear in mind that these two, you need to have it in writing, signed by the copyright holder. Contracts are quite important. Don't underestimate the importance of a contract. As for employment, copyright and employment, say you're an employee and you create something during the course of your employment, you don't own that copyright. The employer actually does. Of course, you need to check your employment agreement. But if you're a work for hire and independent contractor, then you own that copyright, the independent contractor. But as I've said before, check agreements. The issue of copyright, actually, the ownership, it came up in a now infamous case. That would be the monkey selfie case. And what happened was a photographer actually set up his cameras, his gear in a forest. I believe it was a national park in Indonesia. And naturally, monkeys are quite curious. And one of the monkeys actually hit the shutter button and took an exceptionally great selfie. So the issue was, who owns the copyright? Of course, the court held that it's not the monkey. Animals can't hold copyright. It's the creation of the human mind. And of course, it was the photographer who owns the copyright. He set up the gear, etc. So that was a pretty interesting case. It's pretty famous now, and the selfie was great. I'm sure you may or may not have seen it around. It's been published in various publications. So let me move on to related rights. Related rights, actually, you know it as neighboring rights. It protects the interests of those who help bring copyrighted work to the public space. So who benefits would be performers. The performer's voice and likeness is used to promote, for example, a song. So to the producer of the song recording, he or she needs protection. The broadcasting organization would need protection as well, as that transmission is what attracts related rights protection. So that would be the basics of related rights. So there are two types of rights management. We have individual rights management and we have collective. Individual rights management, it's virtually impossible to do on your own, because how can you track down every single person who uses your song or your work, anything that you create? It's pretty impossible. So that's why collecting societies, collective management organizations, that's why they exist. They are involved in management of your rights. What they do is they monitor when your works are used. They license the use of works on behalf of members, and they also collect royalties. They collect fees and they distribute it to you, the rights holders. So that's actually the basics of copyright as it pertains to original literary and artistic works. The second right I'm going to touch on would be trademarks. Now, trademarks is a pretty important right. Is a very valuable asset, particularly to a commercial entity. When you it speaks to branding, basically, brand identity. So when you have a small business, for example, you exist to make a profit, and how do you start off that? One of the ways is to make yourself known, become identifiable. And a great way to do that is the use of a trademark. So what is a trademark? It's a sign or symbol It's used to distinguish goods and services of one entity from another. As I've said before, it's such a valuable asset. Think of the most valuable brands in the world, like Amazon, for example, even Apple. Amazon uses this arrow. It points from A to Z, and I believe it's in the form of a smile. That's pretty memorable, and they are known worldwide for it. As well as Apple. Apple has absolutely nothing to do with the fruit, for a start. But you know of their devices, their quality. Excuse me. You could even think of Microsoft. You could think of Google. Think of all these valuable brands. They all use trademark protection. So your trademark must be distinct. It can't be descriptive. It can't be deceptive. It's got to be distinct. And as I've said, you protect your brand, you protect your business. It's a brand identifier, source of origin. And the right is gained to prevent another person from using it. Once you protect it, of course. And as you can see here, the more your mark is out there, you become more recognizable and you become familiar to consumers. So I'm sure that some of you may have a mark or you're thinking of one, I hope. So protection is done by making an application to our National IP Office to register a mark. You can't actually, unlike copyright, it's not automatic. So first you have to make an application to the IP Office. There's an examination process, of course. And you see here something called the niche classification. The niche classification is where you put some information on the application form and you tell the IP Office what goods and services you want your mark to be associated with. Then there must be a search. You have to do a search to check for any similar marks. Of course, the IP Office will examine it, published in a journal. It will be published for about, I think it's a few months, maybe 3 months. So that's how you register a trademark. I've added in some different types of marks that exist. As you can see here, sound marks. For example, 20th Century Fox musical opening with the trumpet sounding off. There is Homer Simpson's Doe. And of course, everyone knows this ringtone, the default ringtone for Nokia. As for word marks, we have Adidas, Levi's. Angostura actually also uses trademark protection. So too does Crix, I believe. As for, there's a story that came up recently regarding Reebok and how the founder came about the name Reebok. They actually were going to go with some other name. I think it was Mercury. And of course, that was already registered for someone else. So how he went, he chose Reebok was he went into a dictionary and he just kept flipping the pages and stumbled upon that word. I think it's an antelope, an animal. But one of his reasonings for choosing that was he thought about Kodak. Kodak means absolutely nothing, but yet people remember it. And so that's how Reebok basically came about. We've got domain names as well, that's protected. Color marks, such as the red sole on women's shoes, are protected. There is the Toblerone shape, that iconic triangle. I don't think I've ever seen any other candy really in that shape. As for Yamaha in terms and their musical instruments, they actually have such a long history, a rich history of their trademark. They have trademarked many logos, and in the 1800s, their first mark was actually a Chinese phoenix, and that Chinese phoenix was holding a tuning fork in his mouth. And that's what the owner wanted to showcase was quality musical instruments. And the trademark is tied into quality. It showcases the quality of your products that you put out. So the possibilities are somewhat limitless almost. So how valuable is a trademark to your business? It protects the goodwill of business and products. As I've said before, value of your goods, your reliability, etc. It's tied in with that mark. People see that mark everywhere. It helps build your business reputation. It basically simplifies your marketing, becomes more known, etc. And it can make your business or brand easily recognizable, especially in a crowd. Once you build your brand and it's seen everywhere, people are gonna see it. They're gonna know immediately, just like Apple, quality of devices, quality of the product that you put out. And it can influence consumers' buying habits. That's tied in with everything else here. So that's how valuable a trademark is. It's one of the most valuable assets a business could have. So on to some exciting news. You see here the Madrid Protocol. And what is the Madrid Protocol? It's actually the international trademark system. And the reason why it's exciting news is because just last month, Trinidad and Tobago, we've joined this protocol. Meaning, well, actually, let me give you a history first. Before this protocol, if you wanted to protect your mark in other territories, other countries, you'd have had to file so many applications in different languages. You would have had to pay fees in different currencies. So this protocol, this system, it simplifies that, it streamlines it. You file one application, you pay one single fee in one language, which is pretty great. And you could seek protection in multiple countries. I believe this protocol comes into effect in January in Trinidad and Tobago. So that's the benefits. You can take your mark internationally in a much easier way. It's very cost effective. It's especially for small businesses, for individuals, even large corporations. It's a very simple and easy procedure. So you may want to know, how does this system actually work? So according to WIPO, what you need to do is you need to apply through our national IP office. You need to have an application in already or have something registered. That basic mark must be in. And so the IP office would certify it and send it off to WIPO. WIPO conducts a formal examination and then send it off to the contracting parties, the other national IP offices in the territories that you want protection in. So they will conduct an examination using their local laws, and they will see fit if they would like to accept it or not. Remember, trademarks are territorial. They are sovereign rights. If you want protection, you can't just have protection in one country and it's protected everywhere else. Each country has to decide. So third right will be patents. Now trademarks, I hope you see the value of trademarks and how important it is. A patent is a very valuable IP right because it's about innovation, really. So what exactly is it? It's an exclusive right granted to protect an innovation, an invention, and a process as well. So what are the requirements to have a patent protection? It's actually got to be new, meaning we should not see it in our current body of knowledge. It must be new. It must be an inventive step, meaning that it can't be some ordinary person, some ordinary skilled person. If it's obvious to them, then there would be no patentability. And of course, being useful, industrially applicable, just means that it has to work. Now, you don't need to have some big technology to get a patent. It could just be that you are improving on some new technology, something even a simple household item. Maybe you want to improve on the vacuum, I don't know. So protection for patents. this is not renewable or anything. This is actually just a limited period of 20 years. But in that 20 years, that protection that you have the ability to stop others from selling, making it, from using it. And as for disclosure, if you have any sort of intention at all to apply for a patent, to get a patent protection, please just keep it confidential. Don't disclose it. Because if you disclose more than a year before you have that intention of applying, it will be considered prior publication. You, of course, have to disclose when you make the application, and you have to disclose it in the application. Another story I would actually like to share is a controversial story with the inventor of the telephone. And that would be Elisha Gray and Alexander Graham Bell. That story is controversial because Bell actually filed the patent for the telephone some hours before Elisha Gray. So the point I'm trying to get across there with that story is, be quick on the draw as well. It's really first to file. If somebody else has the exact same idea, whoever filed first would obtain that patent protection, basically. Just something quick here regarding the Patents Cooperation Treaty. The PCT is an international filing system, and what you can do is file a single international application, one application really, and you can also seek protection in many other countries. Of course, each country will decide on the application using their local laws. And one thing to note as well is that there is no universal, worldwide, international patent. Just like trademarks, territorial, sovereign rights, each country will have to decide if you get that protection in that country or not. You can't just get protection in one country and it's protected everywhere else. So that's the very basics of patents. But how valuable is it to a business? So you have an invention, whether it be improving on some older technology or it's just something completely new. You don't have the means to really produce it. What you can do is you can license your patent to another entity who has the means of production, and that would be a really great revenue stream for you. It would also encourage the growth of an entity. All that time you spent researching and developing, you could actually, through licensing, that revenue, you can recover research and development costs. And lastly, promoting innovation. This really would benefit society on a whole. Innovation is needed because inventors, they need to know that their invention is being protected. Otherwise, how would you be motivated to invent even more, to improve on technology even more, to help solve human problems? So in a nutshell, that's basically why patents are valuable. So just before I move on to this slide, actually, I just want to give an honorary mention to trade secrets. A trade secret is actually a secret, of course, that would have commercial value, and you use it during the course of your business. And the person who owns it, the right holder, has taken reasonable steps to protect that secret and keep it a secret. So while patents are actually a very solid way of protecting an invention or process, trade secrets is completely confidential because a patent you need to disclose at a certain stage, but a trade secret is very much confidential. And unlike a patent, you don't need to register it. You don't need to seek protection through the IP office, etc. No formalities there. So some examples of a trade secret will be a recipe, such as KFC or Coca-Cola. You could also protect your manufacturing process through a trade secret. There's also client list, financial information, things like that, that has commercial value to it, and it's a secret. It will be protected via trade secret right. So our last slide is actually the importance of an IP strategy. IP protection basically rewards the expression of the human intellect, and protection obviously can generate revenue such as licensing. You would want to create more to innovate more. And IP is so important because, as I've said at the start, our human imagination, how we express ourselves, we express through creation and innovation. Innovations can help solve many problems, many small problems that we have. If you're inventing some new sort of cancer treatment drug, for example, something like that, innovation helps, and protection of it is needed. If you don't have protection, we won't be motivated to create. So think about your business goals, the business values, and think about it along with an IP strategy. Our last point here, it can assist with business marketing strategy in relation to brand image. Of course, that relates to a trademark. Trademarks are so important that it's a brand identifier. So all in all, I gave you an introduction to IP, a very basic introduction actually, and why IP is important. You should learn how to harness it, learn how to exploit it commercially, because it really is a great tool for you in your business as well. So that would conclude the end of my presentation. If you have any questions, you can actually direct it to MusicTT, or you can direct it directly to me actually via email. All right, so I've seen a few questions. So I see trademarks are crucial to your overall branding. Can you explain further the importance of registering your trademark in Trinidad, and is registering your trademark in Trinidad valid for the, no, it's not. Remember, it's territorial, but of course, there is actually the Madrid protocol that I hope everyone would take note of. It's pretty exciting. And you license your rights and still exploit. Remember, licensing, you could actually keep that up, your rights on as your own. You own it, but you can license it and have someone else use it. But remember, you get a revenue stream through licensing. If you do have any other questions, you can certainly direct it to MusicTT, and as I've said before, either MusicTT or direct it directly to me. Oh, is there another question? Approximate cost of registering a trademark. I believe the cost currently is $1,400, but you can definitely contact the IP office to confirm that. But I believe it's $1,400 currently. But $1,400 and you get 10 years protection, so that's a great deal. So thank you everyone for tuning in and listening. I hope you understand the importance of intellectual property and you understand the basics of it as well. I hope you enjoy the rest of Global Entrepreneurship Week as well. And thanks to MusicTT for allowing me the opportunity to host this webinar. As I've said before, please direct all questions to either MusicTT or to myself via email. Thank you, everyone.